Minnesota Realtor License Exam Prep. Question 1. Before Taylor schedules the salesperson examination after studying in St. Paul, which pre-license course must already be completed? Option A, Course I. Option B, Course 2 only. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option A, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 2. A legal description refers to township, range, and section. Which survey system is being used for Cameron in Northfield involving a duplex priced at $271,000? Option A, meets and bounds only. Option B, rectangular government survey system. Option C, lot and block only. Option D, a gross lease system. The correct answer is option B, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 3. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Quinn in Bemidji involving a condominium unit priced at $415,000? Option A. The licensee must obey every instruction from a client. Option B. The defect becomes confidential forever. Option C. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option D. The buyer's broker alone must discover every defect. The correct answer is option C. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 4. If one broker represents both Kendall and Gwynn and Riley Nolan in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. Consent is unnecessary if two different salespersons are involved. Option D. All parties must give informed consent to the dual agency relationship. The correct answer is option D. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 5. A Duluth buyer's loan has small monthly payments but one large final payment. What is that final payment called for Finley in Duluth involving a farm parcel priced at $369,500? Option A, balloon payment. Option B, proration credit. Option C, replacement reserve. Option D, equity dividend. The correct answer is option A, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 6. A landlord in Blaine deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Schuyler in Blaine involving a townhome priced at $305,500? Option A. They are based only on the landlord's dislike of the tenant. Option B. They are tied to permitted reasons and supported by a written explanation. Option C. They include normal fading of paint from ordinary use. Option D. They are taken without notice because deposits are always non-refundable. The correct answer is option B. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 7. A buyer pays 3% in discount points on a $206,100 loan. Approximately how much are the points? Option A, $1,159. Option B, $22,900. Option C, $6,183. Option D, $13,740. The correct answer is option C, $6,183. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 8. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Finley in Duluth involving a farm parcel priced at $250,000? Option A, immediate ownership and possession of the property. Option B, a life estate measured by the borrower's life. Option C, a leasehold estate for the loan term. Option D, a lien securing repayment while the borrower retains title. The correct answer is option D, a lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 9. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Sawyer in Maple Grove involving a rental house priced at $296,000? Option A, sales comparison approach. Option B, cost approach only. Option C, income approach only. Option D, a front foot method only. The correct answer is option A, sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 10. In appraisal, what does highest and best use require for Rowan in Red Wing involving a single-family home priced at $290,000? Option A, the use that produces the highest commission. Option B, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Option C, the use preferred by the current tenant only. Option D, the use with the lowest property tax bill. The correct answer is option B, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 11. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Kendall in Rochester involving a townhome priced at $376,000? Option A, a verbal request from one salesperson. Option B, a social media announcement that the deal is done. Option C, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D, the buyers hope to renegotiate after closing. The correct answer is option C, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 12. A deed is signed by the grantor but never delivered to Emerson Davis, Why is delivery important? Option A, delivery sets the mortgage interest rate. Option B, delivery replaces legal description requirements. Option C, delivery creates a leasehold only. Option D, delivery shows the grantor's intent that the deed take effect. The correct answer is option D. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 13. A parcel borders a non-navigable stream. Rights connected to that water are commonly called what for res in Edina involving a lake cabin priced at $310,500? Option A, riparian rights. Option B, littoral rights only. Option C, emblement rights. Option D is subrogation rights. The correct answer is option A, riparian rights. Riparian rights relate to land adjoining rivers or streams. Littoral rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 14. A $449,000 sale carries a 6.5% commission. What is the total commission before any split? Option A, $67,350. Option B, $29,185. Option C, $9,541. Option D, $8,980. The correct answer is option B, $29,185. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 15. Why should a purchase agreement for a condominium unit in Duluth be in writing and signed by the party to be charged for Finley in Duluth involving a condominium unit priced at $235,000? Option A. All oral contracts are criminal offenses. Option B. Only lenders may sign real estate contracts. Option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 16. When Cameron, a licensee, intends to buy a client's property in Maple Grove, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The disclosure is needed only after the deed is recorded. Option C. Only the buyer's lender must be told about the license. Option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. The correct answer is option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 17. A lender offers Taylor Peterson a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, adjustable rate mortgage. Option B, package mortgage only. Option C, open-end listing. Option D, a graduated lease. The correct answer is option A, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 18. A licensee in Northfield drafts a complex legal clause for Avery Peterson instead of recommending legal counsel. What risk is created? Option A, constructive eviction. Option B, unauthorized practice of law. Option C, functional obsolescence. Option D, inverse condemnation. The correct answer is option B, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 19. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Rowan in Red Wing involving a mixed-use property priced at $374,500? Option A, riparian rights. Option B, deed restrictions. Option C, trade fixtures. Option D, remainders. The correct answer is option C, trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 20. A listing agreement for a Rochester seller is missing a definite end date. Why is that a licensing problem for Kendall in Rochester involving a townhome priced at $298,000? Option A, listing agreements are valid only if they renew forever. Option B, expiration dates are allowed only in commercial leases. Option C, the county recorder assigns the expiration date after closing. Option D, Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 21. In Duluth, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Finley in Duluth involving a vacant lot priced at $451,500. Option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option B. Be at least 21, complete only course I, and work independently after passing the exam. Option C, complete continuing education before any pre-license education and apply directly without a broker. Option D, pass only the national exam and begin practicing while the application is pending. The correct answer is option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 22. A buyer includes an inspection condition in a Bemidji purchase agreement. What is the role of that contingency for Quinn in Bemidji involving a farm parcel priced at $377,500? Option A. It automatically transfers title to the buyer. Option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 23. A city takes private land for a public road after paying just compensation. What power is being exercised for Casey in Bloomington involving a vacant lot priced at $223,500? Option A is cheat. Option B, adverse possession. Option C, eminent domain. Option D, police power only. The correct answer is option C, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Cheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 24. If Avery Okafor tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, keep the information confidential until the closing date. Option B, cancel the agreement without telling the buyer. Option C, disclose only if the seller misses a loan contingency. Option D, immediately disclose the stated intent not to perform to the other party or parties. The correct answer is option D, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 25. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Hayden and Brainerd involving a townhome priced at $451,000? Option A, tie-in arrangement. Option B, accretion. Option C, estoppel. Option D, substitution principle. The correct answer is option A, tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 26. Which document is used to convey ownership of real property from grantor to grantee for Cameron in Northfield involving a rental house priced at $262,000? Option A, promissory note. Option B, deed. Option C, listing presentation. Option D, home inspection checklist. The correct answer is option B, deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 27. A deed gives Reese possession for life, then ownership passes to Drew Johnson. What interest does Drew Johnson hold before Reese's death? Option A, leasehold estate. Option B, easement in gross. Option C, remainder interest. Option D, mortgage lien. The correct answer is option C, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 28. A sudden flood removes soil from a riverbank in Crow Wing County. What term describes the sudden loss? Option A, accretion. Option B, assemblage. Option C, plottage. Option D, divulsion. The correct answer is option D, avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 29. A licensee in Northfield wants to know which required continuing education topics must be included in the renewal cycle along with the general module for Cameron in Northfield involving a rental house priced at $330,000. Option A, agency law and fair housing. Option B, only appraisal theory and mortgage underwriting. Option C, only property insurance and income tax preparation. Option D, only construction codes and zoning administration. The correct answer is option A, agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 30. Two brokerages agree that one will work only north of Blaine and the other only south. What antitrust violation may this suggest for Schuyler and Blaine involving a small retail building priced at $466,000? Option A, redemption. Option B, a market allocation. Option C, assemblage. Option D is subrogation. The correct answer is option B, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 31. A zoning ordinance limits building height in Brainerd. What government power is most directly involved for Hayden and Brainerd involving a townhome priced at $205,000? Option A, eminent domain. Option B, this cheat. Option C, police power. Option D, taxation only. The correct answer is option C, police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 32. If annual property taxes of $2,750 are prorated to the seller for 248 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $22,470. Option B, $5,136. Option C, $1,498. Option D, $1,868. The correct answer is option D, $1,868. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 33. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Hayden and Brainerd involving a townhome priced at $267,000? Option A. The broker has no duty to disclose specific registry information beyond the required notice. Option B. The broker must personally investigate every nearby resident. Option C. The broker must guarantee no offenders live in the city. Option D. The broker must cancel the purchase agreement automatically. The correct answer is option A. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 34. A lot has 50 front feet worth $120 per front foot. What is the indicated front foot value? Option A, $3,267. Option B, $6,000. Option C, $13,335. Option D, $407,143. The correct answer is option B, $6,000. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 35. If a seller rejects Hayden Wilson's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. No later than the next business day after rejection. Option D. After the broker deducts marketing expenses. The correct answer is option C. no later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 36. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Kendall in Rochester involving a newly built townhouse priced at $242,500? Option A, blockbusting. Option B, estoppel certificate. Option C, defeasible fee only. Option D, illegal non-conforming use. The correct answer is option D, legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation, estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 37. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Jordan in Mankato involving a lake cabin priced at $263,500? Option A, highest and best use. Option B, tie-in arrangement. Option C, novation. Option D, steering. The correct answer is option A, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 38. A salesperson discovers an error in an advertisement after publication. What is the most professional next step for Quinn in Bemidji involving a vacant lot priced at $315,000? Option A, ignore it because errors in ads never matter. Option B, promptly correct the advertisement and notify the broker according to office procedures. Option C, blame the buyer publicly. Option D, delete all transaction records. The correct answer is option B, promptly correct the advertisement and notify the broker according to office procedures. Advertising must be accurate and compliant, so prompt correction and broker notification are appropriate. Ignoring errors, blaming clients, or deleting records creates greater compliance risk. Professional practice requires correction and documentation. Question 39. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Emerson in Stillwater involving a condominium unit priced at $231,000? Option A, Minnesota Statutes Chapter 287 only. Option B, the Federal Internal Revenue Code only. Option C, Minnesota Statutes Chapter 82. Option D, a local MLS policy manual only. The correct answer is option C, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 40. Why would an appraiser rely heavily on the cost approach for a newly built townhouse in Rochester? Option A, it ignores land value completely. Option B, it is the only legal method for all residential property. Option C, it values the property only by monthly rent. Option D, replacement cost and depreciation can be estimated more reliably for new improvements. The correct answer is option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 41. A lender draws a line around a Rice neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Blair in Eden Prairie involving a condominium unit priced at $428,000? Option A. Redlining. Option B. Plottage. Option C. Accretion. Option D. Estoppel. The correct answer is option A. Redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 42. A deed expressly creates survivorship between co-owners of a newly built townhouse. Which ownership feature is being emphasized for Morgan and Egan involving a newly built townhouse priced at $319,000? Option A. No right to possess the property. Option B. Right of survivorship in joint tenancy. Option C. A tenant's trade fixture right. Option D. A mortgagee's foreclosure priority. The correct answer is option B. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 43. Why is the Minnesota agency disclosure form given to Casey Garcia not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option D. It gives the consumer a license to sell property. The correct answer is option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 44. A Harbor Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Finley in Duluth involving a farm parcel priced at $268,500? Option A. No, only a paper binder signed by every buyer is allowed. Option B. Yes, but only if clients pay a records fee. Option C. No, statutes are never required in real estate offices. Option D. Yes, access to required statutes and rules may be made available electronically. The correct answer is option D. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 45. During a first substantive contact with a residential consumer in Brainerd, what disclosure should the licensee provide? Option A. An agency disclosure form explaining available agency and facilitator relationships. Option B. A final closing disclosure showing loan terms. Option C. A county tax statement for the current year. Option D. A deed prepared for recording. The correct answer is option A. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 46. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used for Drew in Minneapolis involving a mixed-use property priced at $268,500? Option A. Rectangular survey only. Option B. Lot and block. Option C. A monument list description. Option D. A front foot appraisal. The correct answer is option B, lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 47. A broker tells competing firms to keep commissions at the same percentage in Brainerd. What legal risk is most obvious for Hayden and Brainerd involving a newly built townhouse priced at $337,000? Option A, accretion. Option B, constructive eviction. Option C, price fixing under antitrust law. Option D, of functional obsolescence. The correct answer is option C, price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 48. Before advertising Hayden Thompson's single-family home to the general public, what must a Minnesota licensee obtain? Option A, an oral promise that the owner may list later. Option B, a buyer's pre-approval letter. Option C, a tax parcel map from the county. Option D, a signed listing agreement or other signed written authorization from the owner or authorized person. The correct answer is option D, a signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 49. A Minnesota salesperson renewal fee includes a contribution to which fund for Riley in Woodbury involving a lake cabin priced at $431,500? Option A, Real Estate Education, Research and Recovery Fund. Option B, Federal Flood Insurance Reserve. Option C, County Recording Technology Fund only. Option D, Private MLS Scholarship Account. The correct answer is option A, Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 50. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat the issue for Sawyer in Maple Grove involving a rental house priced at $300,000? Option A, it is always a material defect in the property. Option B, the location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Option C, it requires a separate appraisal license. Option D, it makes the deed void. The correct answer is option B. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 51. A salesperson tells owners in Eagan to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Morgan in Eagan involving a newly built townhouse priced at $241,000? Option A, reconciliation. Option B, hypothecation. Option C, blockbusting. Option D, assemblage. The correct answer is option C, blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 52. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Taylor and St. Cloud involving a duplex priced at $410,000? Option A, gross rent multiplier. Option B, capitalization rate. Option C, straight line depreciation. Option D, metes and bounds. The correct answer is option D, metes and bounds. Metes and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 53. A licensee directs families with children only toward one area of Woodbury. What fair housing problem does that conduct create for Riley in Woodbury involving a single-family home priced at $423,500? Option A, steering. Option B, amortization. Option C, subordination. Option D, novation. The correct answer is option A, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 54. A built-in dishwasher is attached and adapted to a vacant lot. What is it most likely considered in a sale for Quinn in Bemidji involving a vacant lot priced at $334,500? Option A, emblement. Option B, fixture. Option C, trade name. Option D, license. The correct answer is option B, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 55. If Skylar passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required for Skylar and Blaine involving a small retail building priced at $300,500? Option A, 30 days from passing the examination. Option B, 3 years from passing the examination. Option C, 1 year from passing the examination. Option D, until the next broker renewal cycle only. The correct answer is option C, 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 56. A parcel borders a lake near Red Wing. Rights associated with use of the lake shore are commonly called what for Rowan and Red Wing involving a single-family home priced at $336,500? Option A, riparian rights only. Option B, fixture rights. Option C, novation rights. Option D, literal rights. The correct answer is option D, literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams, fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 57. While interviewing with 2 firms in St. Paul, Taylor asks how many Minnesota brokers may supervise the salesperson during the same period. Option A, 1 actively licensed broker. Option B, 2 brokers if both brokers consent. Option C, any number of brokers if the salesperson discloses the arrangement. Option D, 1 broker for residential sales and a separate broker for leases. The correct answer is option A, 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 58. Which ownership estate gives Quinchin the greatest bundle of rights with no stated end date or condition? Option A, estate at sufferance. Option B, fee simple absolute. Option C, life estate. Option D, license. The correct answer is option B, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 59. A social media ad for a farm parcel in Eden Prairie uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. Only the property street address. Option C. The real estate brokerage name. Option D. Only the team logo without the brokerage. The correct answer is option C. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 60. For Hayden Wilson's first real estate job in Rochester, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The listing client from the applicant's first transaction. Option C. The county recorder in the county where the applicant lives. Option D. The licensed real estate broker with whom the applicant is associated. The correct answer is option D. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 61. An easement benefits a neighboring parcel by allowing driveway access across Sawyer Garcia's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 62. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Casey in Bloomington involving a farm parcel priced at $240,500? Option A. The buyer is automatically a client forever. Option B. The buyer is a customer unless and until a written representation contract is signed. Option C. The buyer becomes the broker's employee. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option B. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 63. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Kendall in Rochester involving a townhome priced at $414,000? Option A. It is always protected opinion regardless of knowledge. Option B. It is allowed if the buyer gets a loan. Option C. It is a factual misrepresentation about a material property condition. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option C. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 64. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Casey in Bloomington involving a farm parcel priced at $402,500? Option A. Avulsion. Option B. Condemnation. Option C. Defeasance. Option D. Accretion. The correct answer is option D. Accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change, condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 65. A Bemidji parcel contains 3 acres. How many square feet are in the parcel? Option A, 130,680. Option B, $15,400. Option C, $138,950. Option D, $3,216. The correct answer is option A, 130,680. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 66. A rental property produces $54,500 in net operating income and investors require a 8.5% capitalization rate. What value is indicated by the income approach? Option A, $273,000. Option B, $641,176. Option C, $242,000. Option D, $14,250. The correct answer is option B, $641,176. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 67. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Taylor in St. Cloud involving a fourplex priced at $211,000? Option A, adverse possession. Option B, yield spread premium. Option C, reasonable accommodation. Option D, defeasance clause. The correct answer is option C, reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 68. If Taylor fails to complete required continuing education by the renewal deadline, what license consequence can occur for Taylor in St. Cloud involving a rental house priced at $204,500? Option A. The license automatically converts to a broker license. Option B. The license becomes a deed restriction. Option C. The license renews for free without further action. Option D. The license can become inactive. The correct answer is option D. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 69. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Kendall in Rochester involving a small retail building priced at $393,000? Option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option B. Keep the entire deposit automatically as a cleaning fee. Option C. Apply the deposit to the broker's commission. Option D. Record the deposit with the county as a deed restriction. The correct answer is option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 70. Under federal fair housing law, Which group is a protected class in the sale or rental of housing for Kendall in Rochester involving a townhome priced at $224,000? Option A, credit score above 700. Option B, familial status. Option C, preference for lakefront homes. Option D, employment in real estate sales. The correct answer is option B, familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 71. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Duluth office for Finley in Duluth involving a vacant lot priced at $377,500? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 72. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Kendall in Rochester involving a townhome priced at $436,000? Option A. A guaranteed appraisal. Option B. A material title defect. Option C. A deed restriction. Option D. Puffing if it is clearly opinion rather than a factual claim. The correct answer is option D. Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 73. During a Minneapolis license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Drew in Minneapolis involving a lake cabin priced at $327,500? Option A. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option B. 10 hours every 4 years with no annual deadline. Option C. 30 hours only during the first licensing year. Option D. Only the required module with no other continuing education. The correct answer is option A. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 74. A utility company has the right to run power lines across a Duluth parcel. Which property right is usually involved for Finley in Duluth involving a farm parcel priced at $188,500? Option A. Estate for years. Option B. Easement in gross. Option C. Divulsion. Option D. A remainder interest. The correct answer is option B. Easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 75. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Avery and Moorhead involving a rental house priced at $387,000? Option A. Preference for a short commute. Option B. Owning 2 vehicles. Option C. Status with regard to public assistance. Option D. Having a fixed-rate mortgage. The correct answer is option C. Status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 76. After passing the examination, Skylar wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Skylar and Blaine involving a townhome priced at $418,000? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. No additional education is needed once the exam is passed. Option D. Courses 2 and 3 must be successfully completed if they have not already been completed. The correct answer is option D. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 77. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Kendall and Rochester involving a townhome priced at $421,500? Option A. Variance. Option B. Certificate of title. Option C. Quitclaim covenant. Option D. Mortgage assumption. The correct answer is option A. Variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 78. A borrower signs a promissory note and mortgage to finance a Maple Grove home. What does the note do for Sawyer in Maple Grove involving a rental house priced at $402,500? Option A. Transfers title to the lender at closing. Option B. Creates the borrower's personal promise to repay the debt. Option C. Sets the zoning classification. Option D. Records the deed tax payment. The correct answer is option B. Creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 79. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Riley in Woodbury involving a single-family home priced at $421,000? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson automatically becomes a limited broker. Option C. The salesperson's license becomes inactive until proper association is restored. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option C. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 80. Recording a deed for a mixed-use property in Clay County primarily gives what type of notice to the public? Option A. Private notice only to the buyer's lender. Option B. A zoning variance. Option C. A guarantee of physical condition. Option D. Constructive notice. The correct answer is option D. Constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 81. A Northfield salesperson asks whether Minnesota state law or a private study guide controls if they conflict. Which source governs for Cameron in Northfield involving a rental house priced at $411,000? Option A. Minnesota law governs the licensing issue. Option B. The private study guide controls if newer. Option C. A salesperson's office custom controls. Option D. The buyer's preferred answer controls. The correct answer is option A. Minnesota law governs the licensing issue. Official guidance makes clear that Minnesota law governs licensing issues. Study guides and office customs are learning tools or business practices, not controlling law. A buyer's preference cannot override statutory requirements. Question 82. During negotiations in Bloomington, Blair Miller changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It is a counteroffer that rejects the original offer and proposes new terms. Option C. It creates a lease instead of a purchase contract. Option D. It keeps the original offer open forever. The correct answer is option B. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 83. A title search finds an unpaid mechanics lien recorded against a Winona property. Why does this matter to a buyer? Option A. It proves the buyer has already paid cash. Option B. It automatically creates a condominium. Option C. It may be an encumbrance affecting title and closing requirements. Option D. It removes all property taxes. The correct answer is option C. It may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 84. Which fiduciary duty requires a broker to follow a client's lawful directions for Quinn and Bemidji involving a farm parcel priced at $436,500? Option A is cheat. Option B, novation. Option C, subordination. Option D, obedience. The correct answer is option D, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 85. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Sawyer in Maple Grove involving a fourplex priced at $375,000? Option A. A charge against benefited property for a public improvement. Option B. A private broker commission split. Option C. A personal credit card debt. Option D. A title insurance premium refund. The correct answer is option A. A charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 86. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Quinn in Bemidji involving a farm parcel priced at $211,000? Option A. The state sets one mandatory commission rate for all residential listings. Option B. Compensation is determined between each individual broker and the broker's client. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option B. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 87. A broker learns that a foundation defect could significantly affect Emerson Garcia's use of a farm parcel in Duluth. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, disclose the material fact to the prospective purchaser. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C. Disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 88. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Cameron in Northfield involving a fourplex priced at $283,500? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 30 calendar days after the first showing. Option D. Within 3 business days of receipt or final acceptance, whichever is later. The correct answer is option D. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 89. Why might Taylor Miller use a quitclaim deed to clear a possible title issue? Option A. It transfers whatever interest the grantor may have without making title warranties. Option B. It guarantees the property is free of every lien. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option A. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 90. What is the main purpose of an owner's title insurance policy for Sawyer Thompson? Option A. To insure the roof against storm damage. Option B. To protect against covered title defects that existed before the policy date. Option C. To guarantee future market appreciation. Option D. To replace the need for a purchase agreement. The correct answer is option B. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 91. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Morgan & Egan involving a newly built townhouse priced at $189,000? Option A. Accretion. Option B. Subordination. Option C. Amortization. Option D. This cheat. The correct answer is option C. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 92. When Riley Kahn buys a condominium unit in Red Wing, what does the buyer typically own? Option A. Only a stock certificate and no real property interest. Option B. The entire building in Severalty. Option C. A temporary license to occupy the unit. Option D. The individual unit plus an undivided interest in the common elements. The correct answer is option D. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 93. Which fiduciary duty requires a broker to keep client money and property properly accounted for Blair in Eden Prairie involving a vacant lot priced at $403,500? Option A, accounting. Option B, the assemblage. Option C, the accretion. Option D, devolution. The correct answer is option A, accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and devolution are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 94. Which Minnesota tax is generally associated with recording a deed that conveys real property for Casey in Bloomington involving a vacant lot priced at $385,000? Option A, mortgage registry tax only. Option B, state deed tax. Option C, utility franchise fee. Option D, federal gift tax return fee. The correct answer is option B, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 95. If assessed value is $238,800 and the tax rate is 18 mils, what is the annual property tax? Option A, $1,244. Option B, $4,776. Option C, $4,298. Option D, $59,700. The correct answer is option C, $4,298. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 96. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Taylor in St. Cloud involving a fourplex priced at $469,500? Option A, federal lead paint pamphlet rules only. Option B, advertising font size only. Option C, dual agency consent wording only. Option D, a property tax and ownership status treatment. The correct answer is option D, property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 97. At Cedar Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Morgan & Egan involving a small retail building priced at $293,000. Option A, Pulse. Option B, MLS Grid. Option C, Torrens Online. Option D, HUD Exchange. The correct answer is option A, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 98. A facilitator working with Rowan and Edina performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, loyalty to the seller only. Option B, confidentiality. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option B, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 99. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Drew in Minneapolis involving a mixed-use property priced at $312,500? Option A. Stay silent because the report always controls. Option B. Destroy the report and order a new one. Option C. Disclose known facts that contradict the report. Option D. Tell only the inspector after closing. The correct answer is option C. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 100. A neighbor receives permission to park on Kendall Rivera's land for one weekend only. What interest is most likely created? Option A. Easement appurtenant. Option B. Fee simple estate. Option C. A mechanic's lien. Option D. License. The correct answer is option D. License. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land. Fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license.